And then, finally, and this is really the most important issue with respect to conscience, is free exercise and accommodation of religion. And this is a longer and more complicated story that I want to talk a little bit more about. Because, of course, the way that these issues usually arise in the conscience context is where the state imposes some requirement on either individual healthcare providers or on institutions, Catholic social service agencies or hospitals or the like, that they conform to some requirement that the state has established. And then the question becomes, is there a constitutional protection for the religious entity to receive an exemption from that requirement by the state? And I should say that on this, the case law has trended in an unfavorable direction for religious institutions the last few decades. That for a long time, and again, this is a compacted story, beginning in the 1960s in a case, Sherbert versus Verner, which was a case involving a woman who was denied unemployment compensation by the state of South Carolina. She was a Seventh-day Adventist, so she observed the Sabbath on Saturday. And one of the conditions for receiving unemployment compensation was that one be willing to work on any day except Sunday. And so she claimed that by being unable to work on Saturday and thereby being denied unemployment compensation, that this was a violation of her right of religious free exercise. And the Supreme Court agreed with her. And per Justice Brennan, the Supreme Court said that where the state imposes a substantial burden on a person's religious free exercise, on their right to follow their conscience, if you will, and this, again, we'll keep coming back to, that in order to do that, the state must show that it has a compelling interest in enforcing this law against this person, and that it's the only way that the state can achieve its interest. And it said that in this case, the state couldn't do that. South Carolina didn't need to require that people work on Saturday. If she wanted to take Saturday off but was able to work on Sunday, that could accomplish the same ends just as well. And so for a long time we had, at least in the case law, theoretically, we had a regime in which religious institutions, although there weren't many cases involving institutions, but individual religious believers could go to court, could claim that a state requirement imposed a burden on their religious free exercise, and that the state could not establish that it was a compelling interest that they be forced to do so. The problem with that is that religious folks still lost a lot of cases, right? There's the famous Goldman versus Weinberger case involving an Air Force officer who wanted to wear a yarmulke. The Air Force said that this was not provided for in Air Force regulations. The court said he was out of luck because the Air Force had a compelling interest in prohibiting people from wearing headwear. There was the Ling versus Northwest Indian Cemeteries case involving running a construction road basically through a sacred Indian burial ground. The Indian tribe claimed a right of religious freedom from the government being able to do this. The court said again, no, you're out of luck. So religious believers lost almost all those cases, except for the one exception to that, and it's actually not clear why the Amish won this case, but it was Wisconsin versus Yoder, which was a famous 1974 case in which the Amish in Wisconsin claimed that a Wisconsin statute that required that all children attend school through the age of 16, and the Amish didn't want children to go to school after 8th grade. The court agreed with the Amish in that case. But again, it's not exactly clear on the reasoning of the case why the Amish got this exception, except that Chief Justice Berger seemed to think, well, the Amish they're so distinct, right? And it's not really a problem if they are allowed out from under this requirement. And so again, what we had was at least this theoretical commitment to protecting religious free exercise coming out of Sherbert, and the view that, yes, the government should be put to the test in many cases to show that it needs, that this imposition on religious free exercise is justified, but at the same time, religious claimants frequently losing their cases. This all came to sort of a head in 1990 in the now famous case of Employment Division versus Smith, in which two Indians who had smoked peyote, which is a sacramental substance in their religion, were fired from their job and then were denied, again, unemployment compensation, interestingly, same issue that arose in Sherbert, were denied unemployment compensation by the state because they'd been fired for drug use. And so they claimed that this was a violation of their religious free exercise, that if there's anything that religious free exercise means, it should mean at least that those who engage in sacramental ceremonial worship that's required by their religion should be protected from state interference with that. And the Supreme Court, Justice Scalia, in writing the opinion, said they were out of luck. And Justice Scalia's view in that case was that where the state imposes a neutral law of general applicability, that is, a law that doesn't seek to carve out special disfavor for religion, but it's just a neutral law of general applicability, religious free exercise claimants are out of luck. They should lose their cases. Because if the legislature isn't willing to grant an accommodation or exemption for the religious believer institution, and instead all they're claiming is an individual license to escape the requirements of a neutral law of general applicability, then the religious free exercise claimant should lose. And so in the 18 years now since Smith was decided, it's been a particularly unfavorable environment in this country for religious free exercise. There's of course a vibrant debate about this question, right? People say, well, that since religious free exercise claimants were losing anyway, it shouldn't make much of a difference that the Supreme Court just kind of cleared up all this loose case law and said that basically acknowledged what was already happening. But it does mean that in a wide variety of contexts it's become extremely difficult in the face of state requirements that impose a burden on religious belief for religious institutions or individuals to win cases. In the case that I wanted to talk particularly about, and in full disclosure I should say that when I was at Williams and Connolly in Washington, I was representing the church in this case. Williams and Connolly for many years has represented the U.S. Conference of Bishops and the Archdiocese of Washington in a range of cases. And it was the case involving Catholic Charities of Sacramento. This case, and I hope you can see why it's relevant, especially in the healthcare context, because there's, for these purposes, there's little difference between the place of a social service agency such as Catholic Charities and Catholic healthcare. The state of California, as many other states, has imposed a requirement that all employers in the state who provide prescription drug coverage must include prescription contraceptives in their drug plans. And this applied to Catholic Charities of California. It applied to Catholic Charities in California, notwithstanding the fact that the legislature had created an exemption in the statute for religion. But in order to claim the religious exemption in the statute, you had to be an organization who employed primarily members of your own faith, who served primarily members of your own faith, and whose primary purpose was as the statute said, the inculcation of religious values. And if you didn't fit that definition, then you couldn't claim the religious exemption in California. Some states have enacted these requirements and have had much broader exemptions for religious believers or religious institutions. Some states have enacted these requirements and have had no exemption whatsoever. California was actually somewhere in between. They had an exemption, but it was so narrowly drawn that Catholic universities, Catholic hospitals and health systems, and Catholic social service agencies like Catholic Charities could not avail themselves of it. Now there are two red herrings in the case that I want to sort of note at the outset. One is that it was a case involving contraception. And of course that made it politically all the more difficult for the church, given, in the view of most, the relative idiosyncrasy of the church's teaching on the issue of contraception. But of course, the fact that it involved contraception is constitutionally irrelevant, notice. I mean, it may be a source of considerable dispute within our Catholic community, but the fact that it involved contraception is immaterial from a constitutional perspective, because from a constitutional perspective, the only relevant question is, does this impose a substantial burden on religious belief? If it does, if it's a bona fide religious belief and this imposes a substantial burden on it, then the courts are in no position to then pry around and ask, well, is this a reasonable religious belief or not? Just like the peyote smokers in Smith, right? We shouldn't it's no business of the state to ask around and poke around about whether or not this is a reasonable belief or one that's widely accepted even within that community. The fact was that Catholic Charities was in good faith asserting that this imposed a substantial burden, and that's sufficient. The second, and this is, I think, a more interesting red herring, as I say, is that the statute only required those employers that provided that benefit in the first place to include prescription drugs. So whenever I would talk about this case with other people, their first question was, well, then why do they just don't provide the prescription drug benefit at all? Don't give any benefit to your employees at all, and then you'll get out from under that requirement. But the Catholic institution in that case insisted that alongside its view that it couldn't subsidize the use of the procurement of contraceptives by its employees, at the same time it insisted that as a matter of social justice, it provide prescription drug benefits to its employees. And throughout the litigation, the California Supreme Court especially, there was a certain cynicism about that argument that you saw repeatedly in the courts. That, well, that couldn't really be a religiously, seriously held belief. They took the contraception thing fine, but the idea that it was somehow a requirement of a Catholic institution to provide this benefit to its employees, there was always a certain measure of cynicism about it. Well, so we at Williams and Connolly became involved when we sought the U.S. Supreme Court to review the ruling of the California Supreme Court, which had sided in favor of the state, and we were unsuccessful. The Supreme Court rejected they didn't even agree to hear the case. But our argument was that we've come a long way. Historically, culturally, you can say we've come a long way from a period in which, in the 1950s, 60s, and 70s, in which things, something like abortion or contraception was in Griswold versus Connecticut, which is a 1968 case holding that there was a constitutional right for access to contraceptives by married couples in Connecticut. We've come a long way from a case like that to the view now where it's constitutionally permissible to require a religious employer to subsidize that conduct. And again, whether it involves contraception or not should not be the primary issue. It's the threat to institutional autonomy and conscience that is at the heart of the question, right? And so our view was that we've come a long way as a sort of historical or cultural matter. Legally, of course, this points up the inherent problems with the Smith regime, right? That the post-Smith, post-1990 regime that says that any time the state is acting in a way that's generally applicable and it imposes requirements and doesn't allow for a religious exemption from it, that the state prevails, that regime is a severe, sustained, and serious threat to rights of conscience, both for individuals and for institutions.